I'll just take a few minutes.
Yes, Dr. Yes.
My Lord, in response to your Lordship's question earlier, my Lord, your Lordship indicated that the 81 Act may be half-hearted. I have not two responses to that. The first is, my Lord, the numerical argument in the court. But, my Lord, we don't just have to look at the court. We have to look at the purposes of the university. And these are writ large. I'll read them out from the amended act, my Lord. The purposes your Lordships will find in the original act, it said to promote Oriental and Islamic studies and give instruction in Muslim theology and religion and to impart moral and physical training. Now, what was added, my Lord, in 72 was to promote the study of religion, civilization, and culture of India, and C, which is important, my Lord, which comes in 81, to promote specially the educational and culture and advancement of Muslims in India. So I'm making a distinction, my Lord, with the powers and composition of the court on the one hand, and the purposes of the statute read as a whole. And it is the purposes of the statute that will govern. It's the purposes of the statute which will also run alongside.
Yes.
And that's it. We can't read the act minus the purposes of the statute. And then, my Lord, in Statute 20, there are various, my Lord, faculties and departments which are clearly to promote the Muslim culture. So this is the fundamental, my Lord, distinction that we wish to make. That you go by purpose, you go by empowerment. And to that extent, my Lord, the statute is crystal clear. The second point, my Lord, that I wanted to make draws on Justice, as he then was, Mukherjee's argument in the Bhopal case. And that it says, I'll give your Lordship the citation, 1990, 1 SCC, 613, and para 13. He says we not just examine the provisions of a statute, but also how it works itself out. Now, the de facto de jure, my Lord, are not opposites. They are composites. Therefore, when we mention the de facto argument, it is how the act has worked itself out. And that is a consideration that your Lordships will consider when your Lordship examines how it works itself out. The rest, my Lord, Mr. Sibal will answer. Can I just take your Lordships, my Lord, back to my submission? There are just 2 or 3 paragraphs, my Lord, that I have to read. That is 26 in volume 1A, 1F, yeah, right.
26.
7.3. Muslims have a de facto administrative control over AMU since its founding in 104 years. All members of the first council first court were Muslims. Then all the members of the first executive council were Muslims. 8 of the 12 members of the academic council were Muslims. Every chancellor to date has been a Muslim. 34 out of 37 vice chancellors. And then the vast majorities of the members of the court. 3 non-Muslims were acting vice chancellors. The vast majority of the members of the court, executive council, academic council, throughout the years have been Muslim in nature. Now, because I'm saying we have to examine how the act works itself out, de jure and de facto, my Lord, have to be considered together. Then, my lord, I come to the 7.4, notwithstanding the de facto and jure control, if any provision of the AMU Act is found to be invasive of the minority character, they will be susceptible to challenge. Then, my lord, 7.5 is an important point, and we've just put in the quotation from PA Inamdar. It says that if 1906 restrictions are there which are invasive, then it is 30 that will trump 1906. And over the page, my lord, there is a distinction which I'd made earlier, which I'm reinforcing, between external supervisory control and internal day-to-day control. These are requirements after 1950 to conform to a more egalitarian constitutional setup. It does not denude the institution of its minority character. And then, my lord, apart from 67, well, to 81, AMU has always been a minority institution. And therefore, one of the questions was, why now? The answer to that question, my lord, is it's already been there throughout this particular period, except for this interim wait, which I described in the phases. I don't want to say more than that. I must yield to Mr. Simbo. Lord, I call him my guru from time to time. And Justice Thakur said, who is the guru and who is the shishya? We don't know. Let me end on that, my lord, by way of levity.
Thank you, Dr. Yes, Mr. Sibal.
This matter has been argued at various levels. One, that this university was not established by the minority community, which is the finding in Basha. Then, Mallards, in any case, it was not administered by the Muslims. That's the other level. That's also the finding in Basha. Then, in any case, it is not a minority. That's the third level at which it was argued. And four, that it is an institution of national importance, so it's lost its minority character, even if it had any. These are the four broad submissions that have been made. And I think, Mullah, with respect, greatest respect, that we're going a bit astray constitutionally. What does Article 30 say? All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Let's pause here a minute. If I have not established as a minority, I cannot administer. So I have a right to establish. That's what 30 says. If I have established, then I have a right to administer. So Article 30 gives me a right to administer. It doesn't say that the administration must be in my hands or in Muslim hands or Christian hands. That's not the meaning of Article 30. Administer of my choice, rise to administer of my choice. I have a choice, not you, not the government. But I must establish it. Unless I establish it, that right doesn't accrue to me. And the right that accrues to me is the right to administer the institution as I please, of my choice. Well, let's take, for example, any minority institution in this country. Malad, I don't think any minority institution in this country is administered by minorities. You apply the wrong test, you'll get the wrong answer. Take St. Stephen's. How many teachers are minority? Not even 5%. Administration. How many are filled with Christians? Not more than 5%. Students. How many are Christians? I don't know now, but it used to be 9%, 14%. Well, what's the relevance of that? This whole numerical argument is only irrelevant to Article 30. So, let's kindly take the statute. Take St. Stephen's College in the context of Delhi University statute. The syndicate, I am not part of that syndicate. I'm not part of the executive council. I'm not part of the academic council. That means I'm not a minority institution. What tests are we applying? Never before in the history of this court have these tests ever been applied. That's why there are no judgments cited, Bharat. So, Maharaj, the mistake in Basha was that when Basha said that you have not established this university as a minority, then the council argued, but I am administering it. And Basha said, you're not. That's not the test. So Governor General does this, Rector does this. Maharaj, I want to ask myself a question. If I am enacted by an act of the Central Legislative Council, Maharaj, will there not be a structure by which somebody has to see that I'm not maladministering? Take our constitution today, I set up a minority institution, Maharaj. When I'm setting up that institution, will the chancellor of the institution, which has nothing to do with the minority, not have the right to inspect? He'll have the right to inspect. He'll have emergency provisions. He may even have the right to take over. Administration doesn't mean maladministration. So let's start with the proposition that I have a right to administer. Your Lordship asked a very fundamental question, but the 81 Act is not a status quo ante. The Lordship is right, but I accept it. I accept it. I'm not a minority institution. I still am. That's my choice. And that's the other mistake that we are making, which is an error of law. I don't have to be administered either by the Muslims or the Christians when it comes to minority institutions. You won't have Christians or you won't have Muslims, who are educated at that level to be in every. So, TMA Pi had 4 tests. Para 50 of TMA Pi set up 4 tests. What do you mean by administer? Just kindly come. I've done a rejoinder, Maharaj. It's also part of the kindly come to note 1G. Yes. Page 3 of note 1G. That's why, my learned friends, when I argued this in the beginning, never answered that question. Because 19(6) regulates minority institutions as much as it does majority institutions. Regulation does not mean destruction of the right. So if the chancellor is appointed, by the president, it doesn't mean that I've lost my right as a minority institution. So let's kindly see the TMA Pi para 50.
Where do we get it?
That's my volume 1G,
At page?
Page 3.
Yes.
Ambit of right to administer was set out as including the right to admit students subject to an objective and rational procedure of selection. No problem. That's the institution as the right. The minority, once I establish the institution as a minority institution, I have a right to admit students in accordance with procedure which is fair and transparent. Perfectly good. I'm doing that in Jamia, in AMU. 2, set up a reasonable fee structure. The institution is doing it. 3, to constitute a governing body. We have a governing body. It doesn't say governing body, we must have all Muslims, or governing body, we must have all Christians. Where is it said? Where is that test? 4, to appoint staff. Appoint staff. Nominals. The university says, if you want to teach in AICTE, the teacher must have these qualifications. Abide by that. But the right to choose the teacher is mine. In Delhi University, Manoj, the university provides that if you want to teach economics, the person must be a doctorate or whatever. The choice of which doctorate will teach is mine. But the university will set the standard. That's what it is, to appoint staff teaching and non-teaching. Standards set by the institute, by the structure of the university. And 4, to take action if there is dereliction of duty. These are the 5 indicia of administration. That's 11 judges. Now test this in the context of what Basha said. Now kindly come to Basha for a minute. 3A. Yes.
Is to establish and evidence.
Yeah, I know. In page 16. Yes.
You mean Chandrachud?
I'm sorry, page 16 of Basha at volume 3A, page 16. Annulus praesitum GNH. Wrong argument, therefore the wrong answer. It's not a twin test. Am I administering? That's not the test. And we have all, Maharaj, throughout these days, we've been arguing about, show me if you're administering. It's not required by 30. You'll never get that, Maharaj. That way, there will be no minority institutions left in this country. Apply this to even to the institutions after 2005. All the provisions that are here in the 81 Act are all there in 2005. Inspection, emergency, a final approval, all that. I've got a chart, I'll show it to you. So what are we trying to do? Apply a test which will destroy the entire minority structure, Maharaj, of education in this country?
They don't breathe.
That's why, Maharaj, if your lordships remember, in the opening I said, and your lordships put it also, that your argument is that if I cede that right, that's my choice. To the extent that I cede it. If I feel somebody is interfering, I can challenge it. I can challenge it. I have a right to administer, not a duty that I must administer everything. And no judgment of any court since Maharaj 1950 has held this. That's why I got up and said that numerical strength is not an issue, can never be. I am satisfied with this, Maharaj, and I will go numerically also. Out of the external members, Maharaj, I am 77 out of 104. But, I don't want to fall into that trap. That's why I choose not to challenge. I'm happy. So this is the fundamental constitutional issue that your lordships will have to decide, and consistent with judgments of this court. It's not a twin test. I have the right to establish, I have the right to administer, and of my choice. So, Maharaj, if I am within Delhi University, I am an affiliated college, I accept the discipline of the university. So what is the only choice I have in St. Stephen's? Some element of reservation. That's all, nothing more. And I appoint my own teachers, I dismiss my own staff, I take disciplinary action against him. I have an admissions policy, which now, Maharaj, I don't want to talk about it. That's pending in this court. I had an admissions policy where I could admit students, but with standards. Your lordship knows in private institutions also, those standards had to be applied. You can admit. The Christian Medical College, your lordship knows, they used to hold their own tests at one time. And they had their own standards. The court said, no, when you come to medical seats, you should go by NEET. Fine. That doesn't mean it's not a minority institution.
Mr. Subbal, one clarification.
Yeah.
Just please see one headnote above paragraph 48 in TMFI and just clarify, para 50 applies to minority government aided.
Yes, I'm on government aided.
Just clarify that part.
Yes, I'm government aided.
No, not government aided, but see the headnote above para 48.
Private, unaided, non-minority educational institution. That is the heading.
That applies also to government aided. That also applies to government. It makes no difference. It's all right, non-minority. Same principle applies. Same principle. We are talking about administration. Well, please appreciate. We're talking about administration, nothing to do with minority, non-minority.
50.
I said the test of administration.
Whether the same test would apply for a minority.
It will have to, under 30, it will have to, Maharaj. Your lordship have never said otherwise.
Somewhere provided as to what would be the test for minority. Because this is specifically dealing with private, unaided, non-minority.
Because the argument was that we should not be subject to anything. Please appreciate. Let's test it on first principles. The meaning of administration can't change, Maharaj. Let's test it on first principles, Maharaj. Let's test it on first principles. What does administration mean? Whether it's minority or non-minority makes no difference. Administration can't vary if an institution is aided or unaided, a minority or non-minority. The meaning of administration can't change. unless you find it in section 30, that not only do I have the right, but I must administer the institution all by myself.
Mr. Civil, your argument being.
Whereas para 5 only explains what the right comprises, or 50 only explains what.
It says to admit students.
Yeah. See, if it wants a degree, it cannot. Whereas I'm sorry.
No. This is only institution. DMFI was not concerned with university.
No, it was considered, we're dealing with everything, schools, universities, institutions, everything. Well, let's pause here. I am a non-minority unaided institution, but I want a degree. I'll have to abide by the admissions policy. But I can, within that, admit students of my choice on merit. See, let's talk of first principles here. The right to administer cannot
Can you
change.
say that in a particular course,
Yes,
100% would be from a particular category?
cannot
Can
be.
you say, you can't do that?
You can't.
Can you say that 50% would be from a particular category?
In minorities, yes. That's the law. Yes, that's the law. Within minority institutions, yes. And merit. We can't do away with merit. But that doesn't mean that I've lost my character or I have surrendered. Therefore, let's be clear on first principles here.
No, because in 2004, for the first time, you sought to reserve 50% for the PG course. Prior to that, you did not.
I tell you, Lordship, why? Because I'll come to that later. The area of maneuverability, as I was concerned, had been reduced from 50 to 25%. So therefore, I wanted. And it was struck down, according to me, maybe rightly, but that we're not on that. At the moment, Millers, we are discussing the fundamentals of Article 30. Where do you get this proposition that a minority institution for the Muslim community must be administered only by the Muslim community? Not in Article 30, not in any judgment of this court, not even in TMFI. And this is the proposition that Badshah Mullahs proceeds on. Look at the rector, look at the Governor General, he is not a Muslim. Well, that's the argument. Does the President of India have to be a Muslim to get St. Stephen's minority status? What kind of argument is that?
St. Stephen's. Establishment of the institution.
Yes. Which page? Well, if this were the test, there'll be no institution, Mullahs, which can never claim to be a minority institution in this country.
Argument is, as if a minority establishes an institution, that's good enough for compliance, for getting protection.
Yes, under 30.
Under 30.
Correct.
It's my right, therefore, it's my right to administer.
Yes.
And my right to administer includes these 4 points.
Correct. You may expand it, Mullahs, I have no problems with that. But the right to administer is my choice. I can give up certain rights. I can't waive a fundamental right, as your Lordship knows. But I can give it up for the time being. If I find still interference, I can challenge it. I can choose not to challenge. So St. Stephen says, I just read that. It says the right, exactly what my Lord has said. The right claimed by a minority community to administer the educational institution depends upon the proof of establishment of the institution. The proof of establishment of the institution is thus a condition precedent for claiming the right to administer the institution. That's exactly what my Lord said. And Basha also says that. But Basha says, but you are not governed by Muslims. In fact, Basha should never have gone into this question. If Basha came to the conclusion that that this is not established by a Muslim minority, there was nothing to, it should have stopped there. Why it didn't stop? Because we made the argument, even if we are not established, we are administering the institution. It's a mistake on our part. It's for the first time, my learned friend is agreeing with me on this.
University was not a party.
And university was not a party. No,
My learned friend is in rejoinder. There are several statements which are either inaccurate or misleading.
Well, I'm sure
we want
my
to have
learned
a
friend is
chance to.
My learned friend is very kind always to say that everything that I say is misleading the court.
Not everything.
And the politeness of my learned friend with which you say it is admired by me.
Not everything. I didn't.
Well, what is it that is misleading? Make one statement that is misleading. One statement. Don't just get up only for the sake of getting up.
Mr. Sibal, what is the meaning of para 54 of St. Stephen?
54. Volume 5, yes. 5A, yes. Paragraph 54. Which page is that? Page 422.
St. Stephen's is page 4.
22, my
Page
lord.
50, para 54. It's
422.
5A, page 422.
Yes. That's exactly the point.
Particularly the line,
Yes.
this management must be free from control.
Correct. Of the founder or their nominees can mold the institution as they think fit and in accordance with their ideas of how the interests of the community in general and the institution in particular must best be served. Entirely in agreement with what I'm saying? Entirely. That's my choice. Supposing, Malad, the Vice Chancellor of Delhi University said, I will appoint your teachers. I will decide who will teach in the university. It will be violative of 30. And see, read the rest of the paragraphs. It's all in my favor, Manoj. But the standards of education,
Funds, as you like,
I'm sorry,
whatever public funds you receive,
yes.
can you use it as you like?
No, Manoj, I'm grant in aid, 90% Manoj, grant in aid is given to me. That's, and TMA Pi says, the fact that you're rated has nothing to do with the minority character of the institution. You still retain the minority character. Aid is fundamental.
So the
Duty.
fact that your accounts are audited by the CJI,
It's audited.
does it not make any difference?
No, because it must be audited. I am not absolved of the general principles of law applicable, Manoj. That's nothing to do with the administration. Well, that's to prevent mismanagement, to prevent maladministration. That's why, Manoj, it is to be audited.
Page 416.
One second, hold on, sir, if you don't mind. Allow me, I don't interfere like this, please. Allow me.
That was not right, but I leave it.
I'm sure.
Very good.
Please leave it at that.
Please listen.
Yes.
There are 36. They do have the number test.
Again, do have the number test means what?
416.
You'll find out what it means.
Step. It's finished.
Reading the paragraph. This only establishment of the institution, nothing to do with the administration. Again, you are misleading.
The management.
1 second. This is how the institution is established. Bishop of the diocese, who shall be the chairman? The persons appointed by the bishop of the diocese.
Says management.
He is not managing the institution. This is the genesis of the institution. The North, but let's not have I'm before the court, not before you. The day you become a judge, I'll argue before you.
Go on now, let's.
Anyway, let's not deviate from the issue.
That means 36 does help me.
One second. Sir.
Justifies that 36 does talk of management, does talk of administration.
If you don't, I don't understand what why the learned friend is unnecessarily, but I don't know why. Keep on.
All right, yes, Mr. Sibal. Yes, we now going virtually the end of the arguments. Yes.
No, it's not the end, Malad. It happens to be just the beginning of my argument.
We've got 1 hour and 15
Malad,
minutes.
I can't possibly finish, Malad.
We're close today. We have another matter listed next week.
Well,
Today,
it's impossible to.
We don't mind continuing beyond 4 o'clock, but Mr. Sibal, we have to-
I have not raised any new point. I'm just trying to answer.
No, but this point which you have made, that it's your right to establish, it's your right to administer. And merely because you choose any third party to administer doesn't take away your right to administer in a manner which you think is appropriate. That's the point.
That's the point. That's the point,
It's a
Malad.
right and not a condition.
Yeah, that's correct. That's all. Malad. It's not a right, not a condition, Malad. Absolutely right. Not a directive, not a condition, not a directive, St. Stephen says so. So, Malad, having said that, Malad, now see what mistake Basha made. Okay. 16. Volume 3A, page 16, Malad. Okay. Page 16, placitum G and H, Malad. An argument has been raised, Malad. Might just have that. What's the time? Okay. Placitum G, Malad, at page 16, volume 3A. Plus TMA pi answers the question of aid. TMA pi answers the question of affiliation. None of these conditions, Malad, can take away from the character of the minority institution. So that, Malad, is already covered by this judgment of 11 judges. But Malad, kindly see, if your lordships don't mind, Malad, placitum G, paragraph 3A, at page 16 of Malad, volume 3A, Basha, Malad, volume 3A, page 16, between placitum G and H.
Basha is right.
It's consistent with St. Stephen. That's what I'm saying, Malad. I'm saying exactly that. But then what does Basha say? Kindly see the other paragraph. Page 17. Between E and F, Malad, you see the two words in Article 30 must be read together. And so read, the article gives the right to a minority to administer institutions established by it. If the educational institution has not been established by a minority, it cannot claim the right to administer under 30. Perfectly good. Then, Malad, what does the argument? We have therefore to consider, to examine closely what happened in 1920 when the Act was passed to decide whether in the face of the Act it could be said that Aligarh was established by the minority, whether the right to administer it ever vested in the minority. That's the wrong thing. This is ultimately the conclusion. I'm sorry. There was the other passage which says, no, that it at page 22, in paragraph F, nor do we think that the provisions of the Act can bear out the contention that it was a Muslim minority which was administering the Aligarh University. Well, this is wholly irrelevant. That's not the test. The issue is not whether the Muslim minority were administering the university. Already, Manas, the Basha said, if you've established it, you have a right to administer.
But then why did you challenge the 1951 and 1965 amendments?
I'm sorry?
Why were you mean the sense? Why was the 1951 and 1965 amendments challenged in the first place?
Because it took away my right to administer.
Right. Therefore, that's exactly the point. So the 1951 and 1965 amendments were challenged.
I did not challenge, but just
somebody
challenged.
Right. AMU didn't challenge.
Yes.
It was challenged on the ground that both these amendments took away the right to administer.
Yes.
How did it take away the right to administer? By creating institutions for the governance of the university in which people who are not of the faith or of the confidence of the founders would be brought in. That was the essence of the challenge. Otherwise, if your argument today is right, that once you have established, you are entitled to decide how to administer, then there was no reason to challenge the 51 and the 65 amendments.
With respect, there is a reason, Manas. The reason was they took over the entire control of the university. I was under Basha, not a minority institution.
Therefore,
I was not a minority institution under
Basha.
Basha.
How did they take away the control of the university? They took away the control by, for instance, regulating. First, it said that the proviso to 23 was deleted. Secondly, the constitution of the court was altered.
Correct.
Then they brought in the concept of a visitor. They brought in a whole lot of other changes. Now, that was alleged to be, that was challenged on the ground that it takes away the right to administer.
Correct.
Now, if that be so, if 81 is not under challenge.
No.
Now, if 81 does not restore the position as it stood entirely prior to 1951,
Yes.
then the amendment which is not in challenge has not, though it purported to do that, it has not in fact restored the position prior to 1951.
I agree, Manas. I'm happy with 81. I have no problem with 81.
That's exactly, but you can't be happy with 81.
Why?
81 doesn't go far enough.
No, it's far enough for me, Manas. Please appreciate what I'm saying. It is far enough for me. I am 74 out of 104 in the external members. The court is restored. My voice is heard. The Old Boys Association are represented.
But
I'm happy with that.
That is not because of the 81 amendment. It is about how the working has actually panned out.
No, it's in the 81 amendment, Manas. I'm sorry.
81, if you look at the 81 amendment, the constitution of the court, it doesn't give you 74 out of 100.
It does. I'll show it to you. It does, but this is the mistake I am making, Manas. I'm sorry. This is not the issue at all. As I said to you, on that ground, St. Stephen's is not a minority institution.
But if you are right, that once you establish,
Yes.
then irrespective of whether you administer or not, it's your choice. You can leave administration to a third
I didn't
party.
say that. Irrespective, once I establish it, if the government interferes in my right to administer, I can challenge it. That's all. Nothing more than that. If there are regulations which seek to destroy that right, I can challenge it. Well, that's the limited argument I'm making. I can even challenge some of the 81, but I'm happy with it. Because it continues, my character is maintained. I have no problems with it. What my Lord is putting to me is that I must demonstrate that I am administering as a Muslim the university. No. I was at that point in time in 1920. I don't have to go back to that position. Where does regulation end and infringement begin, Malas? That's the question. That's my right. I have to decide that. That, Malas, with respect, even the court may not decide. Where does regulation end and where does the infringement begin is something I have to decide, Malas.
The difficulty is when we started the arguments, you said we are not going to the question of or, we accepting or should be read as and. Now your argument today is slightly different. what you are saying is, once the minority decides to establish, within inverted commas, establish an institution, then two rights flow. One is they have the right to establish, which is the first right, which is connected with the rights of the minority to establish. And there's a second right, right to administer. Right to administer cannot be read as a condition precedent for declaration as a minority.
That's right. That's what
It's
I've
the
always maintained.
consequence, not the condition.
Yes, I've always maintained that. Mullah.
Now you raise the argument in a very different way.
No, Mullah, but I have always been saying this. And the other day I said to my Lord, the Chief Justice said, that means if you give up your right, you're happy with it. I said that, Mullah, I remember that.
Because now you are arguing it and should not be read as all.
It cannot be read as or, Mullah. And
I think it's a right.
it's a right, Mullah. There's no question of or. Mullah, it is and.
You have both the rights.
Yes, I have both rights. I have always said that. I've never said or, Mullah. I've never contended or. It's a right. It's a right to establish and a right to administer. Now, my right, when somebody infringes my right, whether it's the university or the government, I can challenge it. But to the extent I'm administering it, I feel that if this element of free play in the joints is good enough for me, I'm happy with it. So I'm not in any way saying, Mullah, see, 65 was challenged by somebody, Mullah, but the de facto continued. So in a sense, right from 1950 onwards, this has been an institution, Mullah, which has been actually serving the interests of the minority community, de jure and de facto. The Kerala Education Bill says it must not be overlooked that 31 gives the minorities two rights, to establish and to administer educational institutions of their choice. The second right clearly covers pre-constitution schools. This is exactly what, this has been the law throughout, Mullah. I've never said anything different, but I happen to have argued most of these matters. Otherwise, you'll be laying down a test, Mullah, as I said, no minority institution can ever claim to be a minority on this basis. Article 32 only contains one, Mullah. It doesn't contain two tests. I'll have to show that I established the institution. And the Church of North India established, Mullah, St. Stephen's College. That's the fundamental, Mullah, issue. Basha answered it wrongly because Basha said, no, the Muslims were not administering. Where is it in Article 30 that only the Muslims must administer, or the Christians must administer, or any other community must administer? And what is administration? Running, well, that's the other thing. What is administration? Running the day-to-day affairs of the institution. That's administration, I hope, Mullah. Nothing more than that. If some statute has to be approved by somebody, that's not administration. I have to run the university in accordance with the law. Law is 1906. And Mullah, nobody's answered 1906 on the other side. I've been saying again and again, apply that 1906 to pre-1950. These were all regulations. Of course, Mullah, somebody had to approve. It was the British Empire under which, Mullah, we were being governed. There was a Governor General. There was a proctor. Somebody had to be there. But that's not administering. Administering is running the day-to-day affairs of the university, which means appointing your teachers, holding examinations, admissions of students. That's what administration is. Administration is not some approval that is to be taken by a statute. How many times, Mullah, do you think St. Stephen's have any role to play in an approval taken by a statute, Mullah, or the Executive Council or the Academic Council or the ordinances of Delhi University? Nobody takes. We are governed by it. We're governed by, that's 1906. So these are all regulations of 1906.
Accessible with your argument, then standard of administration of one minority institution will be different than the other minority institution.
Always is.
Because St. Stephen, see the level of what was the interference by the university. and how this court turned down that interference. So now you are accepting that there can be an appointment of a vice chancellor, appointment of a visitor.
Always has been. All minority institutions. Never an exception.
But in that case, the standard of administration in your case will be different than those.
Always another minority institution. Yes. Or other institution. Of course, because the teachers are appointed by me. That's admitted, Mullah. That's the accepted position. That's the administration, Mullah. Everyday running of the university. How do I run the university? How do I run the hostel? The appointment of teachers, disciplinary action against employees. The university doesn't take disciplinary action against my employees. It will take others, Mullah. He can go to court and say, look, this is wrong. That's fine. So, Mullah, all that is governed because that's regulatory. That's 1906. Just read 1906, Mullah. Just read 1906 with me. Nothing in clause G of the said clause shall affect the operation. Sorry, this is 5 because it's it's an occupation. Yeah, nothing in G of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right. That's all. Now, if I find any particular restriction to be unreasonable, I will challenge it. So all these are reasonable restrictions. If approval of the proctor is to be taken, is a reasonable restriction. If inspection is to be done, Mullah, if there are any misgivings about the way it is functioning, that's a restriction. It's reasonable. And that's exactly, therefore, your lordships have said time and again, right to administration is not the right to maladminister. The moment there is maladministration, you lose your right under Article 30. And it's nobody's case that AMU is maladministered. I've been hearing from the other side, it's a great university. It's a university of great excellence. So obviously I must be administering it okay. And it is. So with the greatest respect, Mullahs, please do not apply a test which may be constitutionally suspect. Please do not do that. And therefore, Mullahs, we are going wrong because Basha went on a wrong footing to say that, look, it's not administered by Muslims, therefore, Basha need not have answered that at all because Basha ultimately says, because you're not established, you have no right to administer anyway. But then 1968 judgment took off on that basis. So, Mullahs, I've done with this. I've made my submissions. Then the second submission is that I'm sorry, Mullahs. Yeah, 1 second. I want to show your lordships, Mullahs, factually. Kindly come to my submissions, page, volume 1G, page 15. Yes, 1 second. No, 14, 15.
Execution, supervision and interference.
And you see, so Manas, we have